Your Honors. As a matter of statute, COLAs are not part of the non-applicable rate.
But they're certainly not post-retirement medical benefits, correct?
That is correct, Your Honor.
And that's the only exclusion in 43-3C 95A, right?
958, correct, Your Honor.
So it's
then you
not-
go to 9.5B, Your Honor, and it says a non-forfeitable right to receive benefits as provided under the laws governing the retirement systems or funds. The beginning of sub B lists each of those systems and funds. The TPAF, JRS, the closed systems, PERS, and each of those systems has their own laws. So it's not just, is COLA a benefit? COLA is a form of a benefit, but it is not a benefit within the meaning of the non-forfeitable rate statute. Each pension system establishes its own benefit structure based on years of service, salaries, so on and so forth. But COLA is separate and apart and on top of that benefit. So COLA is not a part of the non-fulfilled right. Nothing that the Attorney General's Office or OLS said in 2006 is contrary to that. Nothing in Judge Perilla's decision is contrary to that. And that is the fullest reading of the limitations on what the legislature intended to create contractual rights.
Let me just, I'm not sure I understand your argument. Are you saying that because the COLA is a separate statute or a separate piece of the statute that applies more generally to these individual pension systems, that's why it's not included in the
Right, it's just not part of the pension benefits. It's a separate additional add-on. And, and as the brief lays out, each pension system has its own laws that lay out what that benefit is, and COLA simply is not part of that. And there's nothing here. COLAs are not mentioned at all. There's no reference to the Pension Adjustment Act in this provision, and there's no basis to assume to grant such a broad reading to the benefits and the laws of the pension system. So, for instance, JRS refers to the retirement system as the JRS. So the phrasing of the retirement systems and funds, that means something. And appellants want to just focus on A without putting that in the context of what is the protection afforded in sub B.
Please stick to the language of A unless there's some problem with the interpretation of that language, given the statutory construction. Why should we look beyond the language of A? It seems pretty clear for purposes of this section. Non-forfeitable right to receive benefits means the benefits program. Any employee for whom that right has attached cannot be reduced. The provisions of this section shall not apply to post-retirement medical benefits which are provided pursuant to law. Where's the ambiguity in that language that would cause us to look closer?
Well, I think first you have to read A and B together. And second, the benefits program they're talking about, each pension system has its own benefits program, and what they're saying is for the members of those systems, that's the scope of the non-forfeitable right that's protected that's defined in 9.5A. The COLA statute, the Pension Adjustment Act itself refers to, it's a monthly retirement allowance or pension. It's an adjustment to that. It's separate and apart from the benefits that are set forth under the laws governing those systems. So the COLAs are not a benefit under the laws governing the retirement system. They're an additional add-on apart each, and the Pension Adjustment Act neither establishes the system nor is not. So I think you have to read 9.5 A and B together, where A is the definitional section and B explains what that means and further defines its scope.